My name is Scott Levy. Today, the topic of discussion is going to be what to do in regards to a DUI. One of our most frequented questions is, I've got a DUI, what next? Well, the first thing that you should realize when you get a DUI is that you face two battles. You have your regular court battle, which everybody is aware of. This is where you're going to fight to stay out of jail, you're going to fight to keep your fines as low as possible, and you're going to basically fight your criminal case. In addition to that, you also have a second battle you need to deal with. You need to fight your DMV hearing. When somebody gets a DUI, you have 10 days from the date of the DUI to put yourself on calendar at the DMV. If you don't do that, they're going to pull your license. They don't really tell you, the officers don't tell you, the jail doesn't tell you, the court won't inform you, the DMV won't inform you, but it's on your temporary license, which they give you when you leave the jail, and on that, on the front page, on the second paragraph, it says you have 10 days to put yourself on calendar. I always advise our clients to call the DMV immediately. You call the driver safety office and you put yourself on calendar. Now, all of the arguments that we're going to be talking about in a minute here in regards to the court hearing apply in the DMV hearing as well. The same California Constitution applies, your Miranda rights apply, your Fourth Amendment right to search and seizure. All of those arguments are the same in the DMV as well as in the court. Now, when you set up the DMV hearings, we're going to subpoena the police officer. This is so extremely imperative to have the police officer present. And the reason for that is, at the DMV hearing, there is no other attorney present. It is the client, myself, the attorney, and the DMV hearing officer. Now, the DMV hearing officer is not an attorney. So I get a chance to cross-examine the officer about impeaching stuff that he wrote in the report and creating inconsistencies. All of the discussion at the DMV hearing is under oath. So all of those statements that he makes can be used in your regular court hearing. The more holes that we poke in this report, the better it is for you, the client. Now, the first thing we start with here at the DMV hearing is probable cause. If we can establish there's no probable cause, if we can show that the officer pulled you over and he didn't have reason, good faith reason to do so, it doesn't matter what you have in your car. It doesn't matter if you have a BAC, a blood alcohol content of 0.55. It doesn't matter if you have a dead body in the back of your car. It doesn't matter if you have a bag of crack in your car. If the initial stop is invalid, if we can show that the probable cause was not there, the entire case would get dismissed. We would file a motion to suppress, or we would ask the hearing officer to dismiss the case based on lack of probable cause. Now, the second thing we're going to go through is the field sobriety tests. If we can show that those tests were done incorrectly and were unreliable, then that would go to your favor. These are arguments we're going to make to the DMV officer to give you your license back, to not suspend your license. The third step we go through is attacking the breathalyzer or the blood test. On the breathalyzer, under the California Code of Regulations, Title 17, an officer must observe your mouth. He must observe your face for 15 minutes prior to blowing in a breathalyzer. And the reason for that is the courts have held that if a person would regurgitate or burp or something of that manner, and that alcohol would go in through your stomach, into your esophagus, in your mouth, it'll give a false reading. So that's something that we make sure that the officer observe the 15-minute rule. If they didn't, we can ask the hearing officer to dismiss those breath tests if they're unreliable. That when a person drinks alcohol and then immediately after drinking alcohol they jump in the car, well, when they're driving, they're not intoxicated yet. That alcohol has not had a chance to metabolize and get in their system. However, if they take your breath an hour later or they take your blood an hour later, absolutely, it's going to show you're a 0.11 or a 0.12. But the important thing is, it's not illegal to be a 0.11 while sitting in a jail. It's illegal to be a 0.11 while driving. So the argument is called rising blood alcohol. And if we can show that you were a 0.05 when you're driving, but an hour later you're a 0.11, then you could win your DMV hearing. You can get a full reinstatement of your license. Now, it's really important to take aggressive steps in these DMV hearings. You have to subpoena the officer. You have to get a copy of the breathalyzer results. Under the California discovery rules, you're entitled to all the police reports and all the things that the officer wrote in those police reports. Under that, it's important you go over those with an attorney. What we do is we will give you the reports to go over for the facts, because we don't know what happened. You're the only one who's going to be able to tell us about this is an inconsistent statement. This statement that the officer said that I said, it's inaccurate. You're the only one who's going to be able to help us with the facts. Now, meanwhile, while you're reviewing the police reports for the facts, we're going to be reviewing them for the law. Did they read you your Miranda rights? Did they violate your Miranda rights? Did they violate your Sixth Amendment right to counsel? Or your the Fourth Amendment, was that violated? Did they search your car without your permission and without probable cause? If we can show any of these things, then there's a chance that you could get your license back and beat that DMV hearing. The most frequent question in regards to the DMV hearing is, what happens if I win? What happens if I lose? Well, we're going to discuss that. If you're successful in the DMV hearing, what's going to happen is you're going to get a full reinstatement of your license. The court, you go down to the DMV and you apply for a new driver's license, and they'll send you one in the mail, and then that part of your case is done. Well, what happens if we lose? What's next? Well, if you lose your DMV hearing and there's no assertions on the police officer that you refuse to blow in the breathalyzer or refuse to give a blood test, if you lose, then there's a 30-day mandatory suspension. It's mandated through the state of California. There's no way around it. However, after that 30 days, we'll be able to help you get a restricted license. And how we would do that is we contact the DMV, we get a copy of your H6, which is your DMV printout. We'll get you enrolled in a DUI school. You don't have to actually attend, you just have to enroll. And then the last thing you need is a proof of insurance, your SR22. So if we can get you those three things and get down to the DMV after that 30-day suspension, we can get you a restricted license, which allows you to go to and from work and to and from your house, and I believe to and from the hospital. That is what happens at the DMV hearing. Now, it's important to be very aggressive in these DMV hearings. If you want your license back, you're going to have to fight to get your license back. The DMV hearing officer is a judge as well as a prosecutor. So you need someone to represent you in that hearing and get your license back.